All right. Good afternoon, everybody. Nothing better to do on a Saturday afternoon than to give the rundown on Justin Baldoni's response to the New York Times request to dismiss his lawsuit. Keith, how are you doing?
Doing good. Yeah. We were just saying, I think 2 days ago, we were wondering if Baldoni is going to respond to the motion to dismiss by the New York Times or just file an amended second amended complaint. And now we have our answer. He decided to oppose and answer the motion to dismiss by the New York Times.
Yes, and overall, I read this quickly. I know you did too. Our good friend Dave Neal, he already has talked about this. I caught a little few minutes of his podcast earlier, and he went over the complaint. But I know we have a little bit different of a flair here, so I wanted to see what we have to say about it. So let me throw the complaint up, and just to give everybody an idea of what's happening here is the New York Times filed a document. We call it a 12B6 motion to dismiss. And it essentially says the jury doesn't need to see this. No courtroom ever needs to see these claims that have been made against the New York Times by Justin Baldoni. And the New York Times is asking the judge to simply summarily throw the case out and make it over. And Justin Baldoni cannot continue his case against the New York Times.
As a matter of law.
As a matter of law.
Yeah.
And so this is Baldoni's response to that. And by the way, the lawyers for the New York Times, I thought, did a fantastic job. I would say that these lawyers did an equally good job in responding to this.
Excellent arguments, very well written, very well composed and presented, and some really good points in here.
So this was, I think, Mr. Schuster and Mr. Friedman that at least they signed their names to this. I'm sure there were some associates. We know at least one associate had some work to do on this case because he signed a declaration that put Ms. Twohey's video into transcript form.
Yeah, exactly.
All right. Well, why don't we go ahead and get started, Keith? I'm just, why don't you tell me a little bit about the preliminary statement here? Just walk me through this what is it? Pietistic bastion?
Pietistic. I love this first sentence. A pietistic bastion of the media establishment, the New York Times, has long presumed itself beyond accountability. Not here. When you read a sentence like that, or when I read a sentence like that, I want to just, get my flowing white hair and be on my steed. It's just like so romantic. But it's such a great opening line. And I like how they use the second, look at that second sentence, not here. Now, this is a device that you use, and I've picked up from you, where you'll make a statement like that, and then the next sentence will be not true or something like that. It's such a good punch. It's just a real punchy way.
I use flat wrong. So what I'll say is the New York Times has said that they're not liable here, but they are flat wrong. That's the idea.
Yeah, and it's just a really nice, quick punch to say not here. That's not going to be the case here. So then they're just talking about Lively's CRD complaint and how the New York Times actively vouched for the veracity of its false narrative. So this is just the opening statement. This is the introduction. So it says, the fair reporting privilege the New York Times seeks to hide behind does not protect it from liability for maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfarer parties. So we kind of knew this was coming, didn't we? The collusion argument.
We knew the collusion argument was coming. We also knew that the New York Times had done a pretty darn good job of describing New York's fair reporting privilege and how New York law should apply, which we're going to get into. But here we're getting a glimpse of Brian Friedman, Baldoni's team saying, hey, first of all, the New York Times needs to be held accountable for the first time in a long time. And secondly, this fair report privilege that they think is going to win this case for them, it doesn't apply.
Yeah. Yeah. And collusion being one of the reasons why it's not going to apply.
All right. Let's go on to a couple other things here. In the second paragraph, there's not a whole lot here, but I noticed that, again, they're pointing out that that the New York Times has said the Wayfarer parties orchestrated a retaliatory campaign to tarnish Lively, and a little further down, falsely accusing them of having waged a smear campaign. So this idea of the smear campaign, was this in the CRD complaint? Where did this idea come from?
Well, it came from Twohey, the reporter, and it was not, that use of that word smear campaign was not in the CRD complaint. And I think that's what they're focusing on in this argument, is that they're saying that the New York Times falsely accused the Wayfarer parties of having waged a smear campaign, quote unquote. And they even go on to say the press enjoys the fair reporting privilege when faithfully relaying the contents of a filed complaint. But is not what the New York Times did here. So that's their argument. The New York Times did not do that here. And look at the next sentence. Not only are they using the term smear campaign, which was not in the CRD complaint, but it also says that it based its article and video, and this is really interesting because they're pointing not just to the article, but the video that Twohey did, which I think is a brilliant move on Baldoni's part, on its reporter's review of thousands of pages of documents. Now, we talked about this before, how it looks like the reporter didn't just base the report that she did on the CRD complaint, but also on reviewing thousands of other documents. Well, okay, now you've gone beyond just reporting on the CRD complaint.
So the fair reporting privilege, according to the New York Times, even when they argued in their 12b6 motion to dismiss, they said, hey, listen, as long as we're talking about a report of a complaint that's been filed at an agency or a court or something along those lines, and here they're saying this was filed with the California CRD, and it wasn't quite filed because it sounds like the article was in progress, the investigation for several months. Yeah. But the point being, they want to essentially put it into a box of, hey, we're reporting on something that was filed with an administrative entity. And the problem is it sounds like there was also thousands of pages of documents, which sound like people said they came by way of subpoena. But I think as we've delved into this a little further, are we finding that maybe there wasn't a subpoena?
I mean, big question mark on that. What subpoena? What case? And you'll see that they make that statement too. But I really like how they constructed our argument. And really what they're saying is that because the New York Times went beyond the CRD complaint, they forfeited the fair reporting privilege. So that's the argument. So there we go.
So let's focus on that. So, can you forfeit a privilege like the attorney-client privilege, the work product privilege, the fair reporting privilege? How do you forfeit a privilege?
Yeah, you go beyond the confines of the privilege. So with attorney-client privilege, for example, when you're communicating with your attorney, all of that is privileged. But if you take an email that is a communication with your attorney and you give it to your best friend and say, hey, take a look at this, you've now destroyed and forfeited the attorney-client privilege, because the minute you share that communication with somebody outside of the attorney-client relationship, you have voluntarily forfeited the privilege, and it can happen just that fast.
So when the New York Times says, and when Meagan Twohey says that she relied on thousands of pages of external documents that have nothing to do with the CRD complaint, that's why, according to Baldoni, Brian Friedman, the New York Times forfeited their fair reporting privilege.
Yeah, because they're not just reporting on something that's filed with a government agency. And, it's an interesting argument, and I think it's a pretty persuasive argument.
All right. So next, I didn't know, I personally would have just given on this issue, but this is great. I mean, I like to see that Brian Friedman and his crew are going to fight this, but it was the group pleading allegation that was made by the New York Times saying, hey, we can't figure out what claims are being made against us. And they're just paragraph after paragraph. There's all these defendants in the case. What's your thoughts on this group pleading?
Well, and I think we'll see when we get down to the argument. I mean, they're saying, the New York Times is saying, you haven't specified which plaintiffs are suing which defendants for which claims. And so Baldoni is saying, we've got close enough. We don't have to spell it out for you. All we have to do is state the claim and just kind of generally say what we're suing for. And that should be, close enough. And not only that, but the section that you just had up on the screen there, they literally say, look, it's premature to require the Wayfair parties to specify the acts taken by the New York Times in connection with its scheme with the lively parties. How would we know? We haven't done discovery yet. You at least should let us do discovery, because we can't get behind the scenes until we take depositions and serve subpoenas and all those things that we have to do.
So this federal court, the Second District of New York, and also California state courts, they have this idea of noticed pleadings.
Yeah.
And of course it makes sense, because you can't prove your case in a pleading. You can't include every single fact that happened in the case, because the point is we may not know all the facts yet, and that's fine. It doesn't mean the facts don't exist. It just means we have the right to do discovery to prove these. So as long as we give you adequate notice of why we're suing you,
right.
And if you, the New York Times, are not smart enough to understand that we're saying that you guys conspired here, you guys were complicit here, you guys were involved in this every step of the way, if you can't figure that out, we'll help you out in discovery.
Yeah, we'll figure it out for you. But that's the whole point of a lawsuit, is you just start with allegations, and allegations are not evidence. They're just statements of fact that help establish this is the claim that I'm bringing.
Something else I thought was really sharp to point out here, and they put it in a footnote. And they're going to say this throughout this. Let me call this out real quickly. They're going to say this throughout their argument here. And they're going to keep returning to the fact that, look, there's a lot of factual determinations that need to be made here, not legal determinations. And because there's factual determinations, you got to leave it to the jury. You got to give a jury the property, the ability. And this comes to basically making claims. And maybe I pulled up the wrong.
No, that's right.
Is that right?
Yeah, because I think the whole point that they're saying there is that they're saying, so the New York Times basically claims in the motion that the First Amendment complaint allegations regarding the metadata associated with the article and video are wrong.
That's right.
But that's a factual determination. Right. And remember, on a 12b6 motion to strike or dismiss, you can only look at the allegations in the four corners of the complaint. You're not allowed to look at outside information. This is a very technical motion. This is not a motion that's based on evidence and fact.
And that's where I was going, Keith, and I knew that I was headed in the right direction. And they say, in summation, this dispute should be resolved by a jury trial.
Yeah, exactly. And so they're just saying, look, just let the facts decide. And the trier of fact in any case is going to be the jury. Unless it's a bench trial, then it's a judge. But this is not. This is a jury trial.
So something I think is interesting, and we had debated whether Baldoni and his team would simply just do a second amended complaint or whether they would actually oppose the New York Times request to have their case thrown out. They've obviously chosen to oppose it. But this relevant background, when I read through this, I thought this was an opportunity for them to tell the story one more time. And some people are going to say, well, yeah, we already know this story. But there's a lot of people that are just getting on the train on this case. And this was a great opportunity to walk through their First Amendment complaint paragraph by paragraph and point out that, hey, there's some bad things that happen here.
Yeah, and it educates the judge. It never hurts to remind the judge of these facts again and again. And it certainly doesn't hurt in the court of public opinion to restate these facts. So you make a good point. It could be that they're going to bring a second amended complaint anyway. But they also thought, hey, let's go ahead and respond to this because it gives us a chance to educate the judge, educate the public, and say it again and again and again.
And even if you have been following this case, it puts it in a nice nutshell. And it's a really quick rendition of what happened. There's Colleen Hoover's novel. There's a agreement to make a movie with Lively. She soon intrudes on production in ways that are beyond the scope of her contractual entitlements. At one point, Lively issued an ultimatum that if Baldoni would not get on board with her work methods, that he may have to recast her role, whatever that means. There was November 9, 2023, this whole 17-point document that kind of surprised everybody.
Yeah.
And it sounds like here again, Justin Baldoni, they point out here again, hey, he just bent over. It was not a big deal. I mean, he agreed with everything that was in there. Not that those things had happened, but he agreed.
Yeah.
Hey, I don't mind. I can go along to make you happy if that's what it comes down to.
Well, and it's interesting too because Brian Friedman, when he was interviewed on the Interview on the Town podcast, he specifically said that, look, Lively presented these 17 things where Wayfair agreed to them, whether they agreed with them or not, they agreed to them. And after that, everything was fine. There's no other complaints after that. So again, they're reciting, this is the narrative. This is the story that they're getting out there.
Okay. So, they went on to talk about she had a tacky and tone deaf marketing plan and that embarrassed her and blew up in her face. And then the first time we see Ryan Reynolds come into the case, so far, first time we see him coming into the recitation of facts here. And if I do this call out here, apparently they wanted an apology of some kind. And that's where they bring Ryan Reynolds into the case for the first time.
Yes. And so this is where Reynolds and Lively wanted Wayfair to issue a statement taking the blame for Lively's bad press. And you can see here, this is where they're saying on the factual assertions, and this is right out of the First Amendment complaint, they cited that the Wayfair parties finally stood up to Lively and Reynolds and refused their final demand that the Wayfair parties put out a false and humiliating statement, which would be factually inaccurate. And then the next statement, again, you can see it's right out of the First Amendment complaint because they cite it. So in response, Lively and Sloan parties worked with the New York Times to concoct a story that would blame Lively's downfall on the Wayfair parties, relying heavily on deceptively spliced private text messages stolen from Abel's phone by her former employer and Baldoni and Wayfair's former publicist, Stephanie Jones of JonesWorks. So that's the allegation that they had in their First Amendment complaint. They're saying it again here because remember, I've said it many times before, I'll say it again, a 12b6 you can only look at the allegations in the complaint, and that's what they're doing. They're looking at the allegations in the complaint. And according to those allegations, Abel's phone and the text messages on those phone was stolen by Stephanie Jones. That's what they're alleging. And that kind of goes back to our question of what subpoena, under what subpoena did they get the documents? I don't know. I don't know what case they would have gotten the subpoena on. According to Baldoni, they apparently didn't get a subpoena because they're claiming it was stolen.
Okay, so the New York Times coordinates its publication with the CRD complaint on December 20th. So that's showing, again, there's collusion between the two. And as a direct result, the Justin Baldoni and his crew, they suffer untold harm. So as admitted in the article, the New York Times relied not just on the CRD complaint but these thousands of pages of documents. We're seeing this theme come up over and over in this response. Why is it so important for the judge to be reminded of the fact that it wasn't just the CRD complaint that the New York Times used, but it was apparently, and again, we haven't seen all of this, thousands of pages of documents?
Because you want to get outside of the fair reporting privilege. So the fair reporting privilege is when you report on a filing in a litigation or a government agency. But when you go beyond what's in that filing, you arguably have gone beyond the fair reporting privilege, and that's when you forfeited the privilege. So they're going to use this argument of thousands of other documents multiple times throughout this opposition.
Okay, and there was we can come back to that in a minute. Let's get to the legal standard. So it's interesting because the legal standards for both sides are a little different. Plaintiffs tend to be much more lax and liberal in their view of what the legal standard is for getting a case to continue on.
Yeah.
And the defendants, the New York Times, they had this very strict interpretation, and they basically said most of these cases are all thrown out on 12b-6. But what's the legal standard?
So let's start with the last sentence first. So it says, in ruling on a motion to dismiss, the court must accept the factual allegations as true, drawing all reasonable inferences in favor of the plaintiff. Now think about that for a minute. That's not what we do at trial. At trial, we don't assume that everything the plaintiff says is true. But this isn't trial. This is a very early motion to dismiss where you're asking the court to take an extreme action. I want you to dismiss this case without a trial and no jury, and nobody's ever going to see it. And so in order to get that type of relief, you can only look at the allegations in the complaint itself. And if you take all those allegations as being true, would you still rule against the plaintiff as a matter of law? So that's the standard that the court has to use.
So if the court is looking at the allegations and reading the New York Times moving document to have the case dismissed, and there's something in there that's pretty darn good, it's strong, and then there's a response to that by Justin Baldoni and his team in this opposition, and it's just a teensy bit stronger, or maybe it's just a teensy bit not stronger, essentially the court is required to give deference to the way that Baldoni
the plaintiff
has pleaded this complaint.
At this stage of the litigation, yeah, for purposes of a 12b-6. And that's why 12b-6 motions are very unique. They're very technical. And it's not a question of whether or not what's said in the complaint is true and established by evidence. It's, have you said enough to simply state a claim, a cause of action under the law? That's all it is.
And by the way, I mean, don't we want cases to go in front of juries if they can, right?
That's the preference. Yeah, we do not want cases being dismissed because we're under our law. A big portion of our law is due process of law, and due process means everybody gets a fair chance to bring forth evidence in front of a trier of fact. And so we don't want things dismissed summarily.
All right, so we get to the first argument. I'll pull that up here, and this has to do with the Rule 8, where there's these combined facts, and there's a complaint by the New York Times saying, hey, we can't figure out who did what, and are we guilty of this, or are we liable for this or that? What's going on here?
Yeah, so Rule 8 of the Federal Rules of Civil Procedure imposes a lenient standard for pleading. So that means you don't have to plead every single little fact and every single little piece of evidence that you're going to bring in. You just have to state generally what the claim. And you can see right there in the quotations, all you have to do is have a short and plain statement of the claim showing that the pleader is entitled to relief. So if I want to plead a claim against you for breach of contract, I'd have to at least state the elements that we had a contract, I performed, you breached, and I suffered damages. And that's pretty much all you have to say. Now, you tend to say a little bit more than that in a complaint, but you don't have to say a whole lot more.
The last sentence is going to run on to the next page. So we're actually going to have to hold the thought as I go to the next page.
I'm not sure I can do that.
But the last sentence, specific facts are not necessary.
Yeah.
The pleading need only give the defendant fair.
Wait for it. How fast can you do it?
There it is. Fair notice. Fair notice of what the claim is and the grounds upon which it rests. And again, this is calling out to me that, New York Times, they've got great lawyers and they're doing a great job and they're really putting together a strong motion to have this case dismissed. And I think Baldoni's team, they've done a really good job in opposing it. Judge Lyman's going to have his hands full with what to do here. But really, the New York Times, do you think they don't understand what claims are being made against?
No, it's a technical argument. It's a technical argument, and they're just trying to get a win on a technical point. And it makes sense that this is the rule for pleading because at the beginning of the lawsuit, you don't have all the facts. You don't have all the evidence. You haven't done your deposition. So, of course, when you plead, it has to be liberal and a simple statement. And so, that's what they're arguing here. And,
it's interesting. I kind of gave up on this argument when I first read it from the New York Times. And I thought, well, it's because you can simply do file, save as, and you can
fix
do
a
second amended complaint and you can quickly fix it. But here it says the Second Circuit, which is where they're at, New York, has noted that Rule 8 does not necessarily require that the complaint separate out claims against individual defendants. Nothing in Rule 8 prohibits collectively referring to multiple defendants where the complaint alerts defendants that identical claims are asserted against each defendant.
There you have it.
And what are the multiple claims here? Collusion.
Yeah, boom.
You guys work together. And what more do you want us to say?
And that's our allegation. And as long as we've alleged that in the complaint, that should be good enough to survive a 12B6 motion. But we'll see how the judge feels about that one.
So the First Amendment complaint gives the New York Times adequate notice of the claims against it. I think that's the notice pleading requirement, right?
Yeah.
And then there's some talk about this, article, video, and CRD complaint, and then the basically two allegations. What was going on here?
Yeah. So, again, I think it's brilliant that they're using not just the article, but the video that Twohey did. And we'll look at that, further down on this. But they're saying the article and the video both are the subject of the defamation. And then, of course, the CRD complaint. And it says there that the allegations in these three documents fall into two principal categories. One, allegations that certain of the Wayfarer parties engaged in a sexual misconduct towards Lively. And two, allegations that the Wayfarer parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation. So those, and according to Baldoni, those allegations are false. And the New York Times either knew they were false or acted with reckless disregard as to their falsity.
I think they went on to say they conspired in secret over a matter of months.
Collusion.
The precise contours of the New York Times involvement were carefully concealed and impossible to fully ascertain without discovery.
Without discovery. So what is that telling you? Hey, judge, give us a chance to find out, and then why don't we let the jury decide?
And again, this is what we, I think I don't want people to be too upset about this. Lawyers for the New York Times are going to do what they can to help their clients. So they are filing this 12B6 with the hope, crossing their fingers, that New York law applies and that they can get this complaint tossed. But here, Baldoni saying, no, not so fast. We want a jury to decide this. And so we have enough here to get past, as a matter of law, we have enough here to get past this being thrown out at this stage, and we want a jury to make that determination.
Yeah, let us get a little further down the road.
Okay, then, Keith, this is something you do really well. I think I'm just going to pull up the first paragraph here that we have highlighted. One of the things we do as lawyers is, when we have cases cited against us, we have a motion filed against us. And here the New York Times has filed a motion and they've cited to authority, case law authority. And they've said, hey, these cases, judge, we win because of these cases. And I think Baldoni's team did a really good job of actually reading those cases and seeing what those cases said. And they start out by saying, hey, those cases that the New York Times is relying on are in opposite. What's the New York Times doing here? What's Baldoni doing here?
They're saying that the New York Times has cited to cases that simply aren't analogous or aren't closely related to this case. And so as lawyers, that's what we do. We find cases and we try to say this case is similar to our case. And now they're coming in and say this case that the New York Times quoted isn't at all similar, because as you can see at the bottom, that case they're talking about and the other cases that they're citing, one of them was one that raised 200 claims against 125 defendants spread across 1,713 pages. Clearly, that's not what we're doing here in our First Amendment complaint. And so that's certainly an extreme case that the New York Times is pointing to, but it's not similar to our case. And for that reason, it's simply not helpful, and it's not the type of authority that this court should follow.
And so Komatsu was the case, and you can see that, it would be hard if you were 125 defendants and there's 200 claims. You would like a little bit of delineation between,
Yeah.
But here it's not rocket science to figure out what the New York Times is being alleged to have done, along with Blake Lively and Ryan Reynolds. And again, this is a notice pleading. We've given you enough to understand we're coming after you
for defamation.
So let's get past this 12B6 and let's get on to the jury.
Yeah, let's get on with discovery.
All right, let's look at next. Now, they spent a lot of time on this, and I think this is going to be a big issue. Why is the choice of law here, the conflict of law issue, so important to this case?
Well, it's a big issue because Baldoni wants California law to apply. The New York Times wants New York law to apply. And one big reason is that California recognizes the cause of action of false light, and New York does not. So there's going to be a number of different claims that are going to be different between the states. And even defamation is a little different between California and New York. And the fair reporting privilege for reporters is a little different between California and New York. So Baldoni wants California law to apply.
So interestingly enough, we're in the Southern District of New York, which is the second district. And we have New York law.
Yeah.
But then we also have California law. Can federal courts apply different states' laws to a case that they're like handling in their courtroom?
Absolutely. Happens every day.
And walk us through that. So if there's a case that's for some reason taken all the way back to New York in the Southern District, but everything happens out in California, so which law applies, California or New York?
And there's rules on that. And so when you're in New York, even New York federal court, there's a law in New York, same in California, same in every state. There's a law that deals with what we call conflict of laws. And so the New York conflict of law statute says that you first have to determine whether or not the laws of the different states are the same or different. Here they're different, because obviously if they're same, that doesn't matter, just apply New York law, but they're different. And then the second analysis is going to be, how is the plaintiff affected? What's the form that's most affected by this claim?
And the claims being different here, that includes some claims you could bring in California that just don't even exist in New York. Is that right?
Yeah.
And then there's also the fair reporting privilege. It's
a little different.
It's analyzed differently under New York versus California.
Yeah, as is defamation to some extent. So, and we'll see here where why it applies, why they're saying that California law should apply. And it kind of goes down that first full paragraph on page 8. So in defamation cases, New York conflict of law, this is the New York conflict of law statute, applies the law of the state with the most significant interest in the litigation. Okay, so what state has the most significant interest in the litigation? And then further down.
Which page are we on?
On page 8.
Okay. Go ahead.
So further down, it says, although the preference for the plaintiff's domicile is not conclusive, the significant contacts in a defamation case are almost exclusively the party's domicile and the locus of the tort. So where the plaintiff resides is going to be a big factor on which jurisdiction has the most to gain or lose from a defamation cause of action. And then if we go to page 9 on the very top, so in this case, California has a significant interest because nearly all of the plaintiffs are residents of California. The two corporate plaintiffs are both incorporated and or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California, and the economic losses to the plaintiffs were felt in California.
You said California a lot there.
It's a lot of California.
All right.
And so that's their argument. They're saying, look, everything that's happening here when it comes to defamation really has an effect more so on California than it does in New York.
By the way, what was the title of this article again that the New York Times made? Wasn't it Hollywood Smear?
Yeah. So yeah, the beginning of making of a Hollywood smear campaign.
Where's Hollywood again?
Yeah, and Hollywood's in California.
Okay, so we're seeing that there seems to be a nexus with California here.
Yeah, right. Exactly. Okay. And if you go down to the next paragraph.
Can I say something else?
Yeah.
Just look at this. There's a very at the bottom here. Some plaintiff was a congressman, and I don't know what that case is about. That's the Condit case. Somebody else can look it up. But here it says reputation necessarily was a matter of national significance, but it mattered most in California where he had been elected to office.
Yeah, so that makes sense. And it kind of makes sense that if you're harmed by defamation, it's harming you probably where you live and work. And if you live and work in California, that's kind of where the harm is. And so that really makes sense. And you can see here that it says, however, the First Amendment complaint itself does not allege that the article is based on information provided in New York by individuals residing in New York to reporters in New York. And discovery will need to reveal, among other things, precisely where the New York Times reporting took place. So where did this information come from? Who gave it to the New York Times? When did they upload it? Where did that happen? So they even say that where the content was uploaded or where the relevant server resided, much less that either event occurred in New York. So it's really it's really that everything's happening in California and the effect of defamations in California. That's going to make it probably more relevant.
And this is a really nice footnote at 7. This is really good arguing. If you're ever trying to persuade somebody of something, act like you're conceding on something, but then show how it doesn't apply. And here they're saying Steve Sarowitz, hey, he's the only non-Californian here, by the way, on the plaintiff side is this billionaire Steve Sarowitz, and he's out of Illinois. Oh, but we're mistaken. Wait a minute. He is out of Illinois, but he's connected with Wayfair, which is a California-based entity. So therefore, essentially, he is also going to be considered for California purposes.
Yeah, and I also like the other part you have highlighted in the footnote where it says the bulk of the harms were felt in California. I think that sums it up really nicely. And that's why ultimately they're saying California law should apply here.
All right. So there was, I don't know why, but this New York Post article, and I think this is the Sackler case. I'm not positive this is the same Sacklers that made money off of selling legalized heroin essentially to people. But there's a New York Post article, and there the Sackler plaintiff brought a defamation claim against the New York Post arising from the publication's misuse of the plaintiff's photo in an online article. And the Sackler court found that the defendant's nationwide publication of his photograph had the greatest effect to the plaintiff and his overall reputation in the state where he resided. So even though it's a national story, it's nationally published, it's from the New York Post, and I love how it's from the New York Post because it's akin to the New York Times.
Right.
We look to where did the harm actually occur?
Yeah, I mean, look at the bottom there. It's, defamation is most likely to be felt in the form where the defamed individual lives, works, and maintains social relationships. Well, that makes sense. I mean, if you're defamed, you're going to feel it, in your everyday life. That's California. All
right. So I need to ask our jury pool: are we going too slowly through this? Do we need to speed up? We can get to the crux of this if we need to, but if you'd like us to go faster, let us know. We're going to keep going with the pace we're going, but if somebody wants a little speed up, let us know. And then again, Keith, a really good job of arguing and lawyering. If you want to take a look at the top sentence here, 2 cases that the New York Times discusses and relies on. That's such a nice way of putting that. They're relying on these cases, Jacob and Kinsley. They're not applicable. And it says both of those courts note that the defamation cases emanated from New York. So again, the facts are different in those cases. So why is the New York Times even discussing and relying on these? Because we have California people here.
Yeah, and then at the bottom you point out what you pointed out earlier. Indeed, the article title refers to a Hollywood smear machine in recognition of the subject's intrinsic connection to California's entertainment industry. Hello.
All right, so I'm hearing from the jury pool that we are doing a good job, and we should keep the same pace that we're doing. So, all right. Let's go ahead. And I do like also when I see good lawyering, and here you had a big, long argument. You had the court's attention, the judge's attention throughout, but you just kind of put a nice summary. Yeah. Nothing like a good summary.
No, a good conclusion is fantastic.
In short, the laws of California can and should supply the remedy for the harm suffered primarily in California by plaintiffs who all live, work, and or do business in California, resulting from conduct aimed at California, all in connection with the entertainment industry centered in California. So fantastic to bring it all in. We just told you everything, Judge, but here's what we told you in 4 short lines.
Yeah, and I think it's a very strong argument. If you compare the argument that the New York Times had on conflict of law versus Baldoni, I really like how Baldoni's side put this argument together. I think they have an excellent shot at getting California law applied here.
All right. So, Keith, this is your highlight. I don't know why you put this here, so why don't you walk us through it?
All right. So we're talking about the sexual misconduct allegations, and this comes under the section that the defamation claim should not be dismissed. So we're on to a new topic. We've already argued conflict of laws, and now we're getting into why should defamation not be dismissed. And they say that these allegations that were made tend to expose the Wayfair parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them in the minds of the right-thinking person, and to deprive them of friendly intercourse in society. Well, think about this for a minute. We know that there's that recording of Ari Emanuel from the Freakonomics podcast, where he specifically, in my mind, he kind of ridicules them in public. So isn't that exactly what they're saying here? Is that, look, we've made allegations that this defamation has caused these types of harms to us. And now we actually know that, well, their allegations aren't half bad, because we know that people are, in fact, ridiculing at least Baldoni in the public eye. So I think they're strong allegations, and they may even be backed by some evidence here. We'll find out.
All right. Next call out. Again, I think this is one of yours.
Okay. So, yeah, again, the court is saying, because this is not a case in which a jury would be incapable of finding that the statements at issue refer to each of the Wayfair parties, the New York Times is raising a question of fact for the jury and not a question of law for the court. Yes, that's exactly what they're arguing. Let the jury decide.
And again, under the 12B6 motion, the New York Times is saying this is only a question of law. And because it's only a question of law, the court can make the determination and dismiss and throw away Justin Baldoni's lawsuit. Justin Baldoni saying, no, there's factual inquiries that need to make here. There's determinations of fact that need to make here. And the judge doesn't do that in a jury case, in a jury trial. It's the jury, the fact finder, that gets to determine the facts.
Yeah, and I kind of like their take on it, which is, a jury's perfectly capable of sorting this all out.
Right. Okay, so then we get to the part that I was most excited about. I was a little let down, not because this isn't great analysis. It's just the New York Times did such a good job of pointing out how they win under the fair reporting privilege. And maybe it is that, Baldoni and his team are just kind of saying, this really isn't that big of a deal. Here, let me just lay it out for you. They don't even address New York law because they're so certain that they were strong on their conflict of laws, or what set of law should be used by the New York court in determining this case. And that's California. And they're so strong, they feel so strong about that. They just analyze this from a California law standpoint going forward.
Yeah, it's a little bit of a gutsy move, because you probably would want to say, in the event the court were to decide that New York law applies, then here's the analysis there. But you're right, they're only looking at this from California. I do like what you highlighted down below there. A report is not fair and true if the publication deviates from the judicial proceedings such that it produces a different effect on the reader than the actual truth of the proceeding. So they're setting up that's the rule. That's the rule that they're saying that it must apply. We'll see kind of what allegations they point to show that the New York Times went too far afield here.
And Keith, not to kick a dead horse too many times, but who is it that determines if there's a different effect on the reader?
The trier of fact. That's the jury.
All right, let's move on to the next page. Oh boy, we've highlighted this whole page. Let me just call the whole thing out, and why don't you tell us anything that jumps out at you that you think is interesting?
Well, look at that first paragraph again in the article and video. So this is fantastic. They're pointing to two different things. I think that is a very smart strategy. And then down below it says, for example, in both the article and video, the New York Times presented an unquestioned fact, the false and defamatory, right? Unquestioned fact, the false and defamatory claim that the Wayfair parties orchestrated a smear campaign. That comes right out of their allegations in the First Amendment complaint. And the New York Times cites to thousands of pages of documents it had reviewed and claims that the text messages show that the Wayfair parties had engaged in the wrongdoing of which Lively accused them. And that's from the video transcript, and they cite to that. So in other words, You're not just citing from the CRD complaint. You're saying that you reviewed thousands of other pages, and upon reviewing those thousands of other pages, it shows that there is a smear campaign. Doesn't that go beyond the fair reporting privilege?
And again, under California law, which is going to be a lot nicer to Baldoni's team than New York, but I don't want to just jump this sentence that you first read. I do agree with you that pointing to the article in the video is an important point. But it says that the New York Times offers its own commentary that goes well beyond merely reporting on the CRD complaint. Because if you just report on the CRD complaint, you might be okay under the fair reporting rule, the fair reporting privilege. But because they relied on those thousands of pages of other documents, that therefore it falls outside the scope of the privilege.
Yeah, and it actually says that in the article, and that's, I think, the argument that they're latching onto, and it's a good. I like that argument.
All right. Anything else you wanted to touch on here, or are we ready to move on?
Down just a little bit down further, it says these extraneous comments and defamatory allegations, at least one of which the New York Times admits was not taken from the CRD complaint. Okay. So that's exactly what they're saying.
Okay. And thus they fall outside the bounds of California's fair report privilege. Again, not even talking about New York law, which the New York Times spent a lot of time going over that.
You know, again, it's a gutsy argument, but I do have to say, after reading their conflict of law section, it does sound pretty convincing that California law should apply. So we'll see how that works out for them.
Okay. So let's go on to the next page. Let me just get this last paragraph called out and let's take a look at it.
All right. So the New York Times vouched for Lively's allegations by affirming that its reporter's independent investigation supported her claims and thus lost the protection of the fair reporting privilege. That's kind of an interesting concept if you think about it, because it's one thing to say, I'm telling you about this complaint that was filed, and here's what they allege in the complaint. It's a different thing to say, and now that I've read this in thousands of other documents, I can affirmatively say, and I've done my own investigative reporting, I can affirmatively say that there was a smear campaign.
Oh, by the way, I didn't ask the other side about this. Well, I did, but I gave them 14 hours to respond.
Yeah, so that their argument is the New York Times didn't just report the CRD complaint; they've literally vouched for it, and so that's what they're arguing here, and it's an interesting argument.
It goes on to say that whether the New York Times publications are fair and true accounts of the CRD complaint are not for the judge to decide, but for a jury to decide.
Yeah, I think that's an interesting argument as well. Let's do our discovery. Let's let the jury decide.
All right, so next we get to the New York Times statements are not constitutionally protected opinions. And I want to slow down here just a little bit, Keith, because this has to do with defamation and it has to do with facts and opinions. Can you just slowly walk us through what's the distinction between facts and opinion in regard to defamation?
The whole idea of defamation is that you're making an assertion of fact. You're making an assertion of something that is capable of being proved true or false, which is what you highlighted right there. And so a fact can be, so if I went around saying that Stuart Albertson is a convicted felon, that's false.
I thought you were going to say that's a fact, but go ahead.
I don't want to be sued for defamation, so I'm not going to say that's a fact. But that is, you can prove that to be true or false. You could go look at the court records and either you are or you are not. If I said Stuart Albertson is a no good, person who, tries to cheat everybody, okay, that's a little bit more on the opinion side, although there is some sort of a factual assertion in there too. If I just said Stuart Albertson's ugly, I think that's just an out and out opinion, even though it's false.
Thank you. Yeah. I was waiting for that.
I know.
Okay. All right. Okay.
There's like a 1 second beat in there when you're like,
So what I want the jury pool to focus in here on is that, look, this is a difficult distinction.
Yeah.
It's difficult because sometimes things are facts, sometimes they're opinions, and then there's sometimes where opinions are facts. I think there's a measuring stick that we can give to everybody to help. And that is the old Supreme Court justice, I forget who it was.
Frankfurter, I think.
Who didn't know how to define pornography.
Yeah.
And how do you define pornography? I'd like the jury pool. I'd like everyone to take a stab at defining in 3 short sentences, what is pornography? Go ahead and try to define it. And Frankfurter, or whoever it was that really wrestled with this issue, he said, look, I don't know how to define it. I'm a smart guy. I don't know how to define it, but I know it when I see it.
Yeah.
And I kind of feel like when you see defamation, when you see somebody being put in a false light in a bad way, where you're trying to harm them based on a false statement or an inaccurate statement, I feel like we kind of know it.
You kind of know it. Yeah. And it's interesting because they say opinions are not actionable until they are. And so there are expressions of opinions that can be actionable when they imply certain things. And so you can see at the top here, expressions of opinion often imply assertion of fact and therefore are actionable. So if I gave my opinion and said I would never buy a car from a crook and convicted felon like Stuart Albertson.
Why do I keep getting up in these hypotheticals?
Just sit there.
Okay, all right, I'll take it.
And that's implying that you are in fact a convicted felon. So it's when I give an opinion, but it's kind of implying something, then that is a factual assertion and therefore it's actionable. And I want to make clear that Stuart Albertson is not a convicted felon.
Okay, thank you. And I'm going to kick the dead horse again, because I do think this is so important. And they say in the last highlighted sentence I have here, the issue of whether a statement is fact or opinion, it goes to the jury. And that goes back to my pornography analogy. The jury knows defamation when they see it. Not everybody can define quite, this is a fact and this is an opinion and this opinion's not a fact. That's hard for law students. That's like a good law school exam. If you have a contracts course or you have a defamation course, I'm sorry, and at the end of that semester, the professor says, tell me the distinction between an opinion and fact, discuss. I mean, there's a lot to write about there, right? But again, I feel like if a jury sees this, tastes it, understands it, looks at it, I think they're capable with their common sense of saying, hey, this is defamation or it isn't defamation.
That's why we have juries. They're there to make that determination for us.
And then, Keith, you had another highlight there on page 17.
Yeah, so this is where the New York Times assertion that the Wayfair parties operated a smear machine that waged a smear campaign was a factual statement that went beyond even Lively's allegations in the CRD complaint, which does not contain these phrases. So once again, the reporter went beyond the CRD complaint. They're outside the reporter's privilege.
Do you think, and again, I'm just musing here a little bit, but Meagan Twohey, she had reported quite extensively on the Me Too movement.
Yeah.
And I didn't read anything that she wrote, but she won a Pulitzer Prize for that, right?
Yes.
Do you think that maybe there's just a little bit that this story sounded so good initially that it was just like, it's so good, we got to write on it, and apparently only write on it once and not follow up and write on it more? But is this just, it was just too much to pass up. This looked so good. And you're looking at the text and you're trying to read them into context. You're not really giving Justin Baldoni and his team other than a few hours to make some cryptic response that this is just a bunch of lies. I mean, was there a search for truth here from your from what you stand, from your analysis and your review of this, or was this where it's like, hey, this is going to be the next Pulitzer Prize, or this is going to really, be something fantastic?
So I remember listening to Meagan Twohey on the New York Times podcast where she was talking about this article that she did. And you read the article, you read the video they're referencing here, and it seems clear to me that in Meagan Twohey's mind, there was a smear campaign. This happened, that it's kind of scary that it can happen. And she raised some interesting questions in the podcast about, is this going to be the wave of the future? Is this how people are going to take each other down? And if so, how does it all work? Which were interesting questions, but I've seen no follow-up articles on it, which would be a very interesting investigative reporting line of questioning, I think. So I think in my mind, it appears as though when Meagan Twohey got this information, she believed it and she reported it as a fact. And I think to this day, she kind of believes it. And once you, I think, have that mindset of, oh, this happened, it's kind of hard to get outside of that mindset, right? You're like, no, this happened. I'm right. And so I don't know that she gave it fair. Obviously, she didn't give Baldoni a fair opportunity to respond, but why not continue to report on it? Why not keep pursuing the story? And that's the part that is very puzzling to me.
Okay. Next page.
Okay, so the statements at issue here were made not in an editorial or letter, but rather in an explosive feature-length expose reported by, among others, the New York Times Pulitzer Prize-winning star journalist Twohey, based on their review of thousands of pages of text messages and email. Now, how many times have we seen thousands of pages of text messages and emails now in this opposition? That's got to be at least the sixth time.
Yeah. Yeah. I don't think it's going to be lost on the judge that it's not just the CRD complaint, it's additional documents. Okay, then they get into this actual malice issue. And, again, I think this is one of those things where actual malice when you see it. It's a very subjective determination. I think the court even says that. But what's going on right here, Keith?
So, and this is a really nice rendition at the top there. To plead actual malice, a plaintiff must allege a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. And actual malice is subjective, but a court typically will infer actual malice from objective facts.
Boy, it makes sense out of that.
Yeah, it's subjective, but we'll figure it out objectively. Okay. But it does, again, it goes back, what they're really saying here is if the New York Times knew the information was false or they were just recklessly disregarding, they didn't care one way or the other, that could be actual malice.
All right, next page.
And this is their point. So it's not just the New York Times failed to adequately investigate, according to Baldoni, but rather it did investigate and obtained and reviewed communications that disproved what it later published and that it edited and spliced documents to mislead viewers. So willfully disregarding, let alone manipulating information, casting doubt on a story is altogether different from negligently failing to investigate in the first place. So that's really the crux of the argument here, is that, of course, this was actual malice because they say that they did an independent investigation, but they didn't. And not only that, but they kind of changed around some of these text messages, or they, worked with Lively's team, according to their opposition. There was collusion. So for those reasons, they're saying there was actual malice here.
So this is obviously the New York Times. It's a hallowed institution, at least it was, and it's
pietistic.
It's pietistic. It's the mainstream media, and we were having a discussion with Zach Peters the other day. I think it was on yesterday, and we were asking, where do people get their news from now? And do we, me personally, I don't even watch TV anymore. I just watch YouTube. That's how I ended up coming to YouTube. I'm like, hey, this looks like fun. You and I like to talk about stupid stuff, so let's talk about it on YouTube. But I feel like that there are Dave Neal, Zach Peter. There's a whole group of people. There's obviously the big hitters, Candace. There's a whole host of them that I'm not thinking of at the time. But the point is, people are getting their news from different sources now. Are we seeing more of that because of this?
It seems like it. And, it's the one thing we're trying to do is let's just look at the source document and talk about it. And, let's dig into it. And then the jury pool can make up their own minds. And I think it's kind of hard to do that nowadays with mainstream media because you just don't feel like you're getting the straight scoop anymore.
All right, so there was these false light and promissory fraud claims, and I think those come under California law. I don't know that we need to spend a lot of time there. The breach of implied fact contract. What I wanted to get to next was, I think, again, Mr. Schuster, Mr. Friedman, and the associates and any other partner at their firms that worked on this did a fantastic job. This is really good. We're seeing, major league athletes here in the legal world. And it's always nice to have that because you're getting the best work on both sides. And it's each side is forcing the other to rise to the occasion. But ultimately what they say is, look, we think the court should just, basically say this 12b6 doesn't count, throw it out. Not a big deal. The case should move forward to a jury. But just in case, what do they say?
Then give us leave to amend and let us amend the complaint again with the second amended complaint, which the court will do. The court's required to grant leave liberally. And every single 12b6 motion has a section like this in it. In state court, we call it demurs. It's the same thing. You always include a section where you say, if the motion is granted, then at least grant us leave to amend, and the court would likely do that.
All right, let's quickly look at the declaration in support. And I want to, we don't give enough credit to associates. Associates always work their tails off. And I just like this guy, Jason Sunshine. He's an associate at Friedman's firm. And so he gets a little name recognition here. That's always nice for an associate. I don't know where he fits in their
pecking order.
Yeah. But he essentially transcribes the video. And you wanted us to take a look at a couple of those transcriptions.
Yeah, so this is a video that was done by Meagan Twohey, and they're citing to this in their opposition. And they're specifically saying here that this is Meagan's own words, what she's saying on the video. She says they hired, meaning the Wayfair parties, hired a crisis PR manager who orchestrated a smear campaign against Lively. Well, that sounds like that wasn't in the CRD complaint. That sounds like a conclusion and a factual assertion that Meagan Twohey is making directly.
Okay. And then down below, there was another call out you wanted to take a look at.
Yeah. And again, at the same time, Nathan assembled a team that could dominate social media through full social account takedowns by starting threads of theories and...
Hold that thought.
Here we go. Generally working to change the narrative. So it's impossible to know how much they planted and how much of it originated organically. Well, wait a minute. That assumes that it was planted and that it did originate in some other way other than organically. So again, it's implying something. So you could say that's an opinion, but in my mind, that's implying that they did in fact plant something and some of it was not organic. And right there where it says, whatever the case, they seized on it and amplified it. So again, you're making a factual assertion that these people did something, seizing on it and amplifying it.
And then this is the area that you were interested in.
Yes.
Go ahead and give me your thoughts there.
But this story reveals a new playbook for waging a far-reaching and largely undetectable smear campaign in the digital age. Okay, this is exactly what I was saying earlier. You're making an assertion that sounds like an opinion, but you're doing it in a video where you're talking about the Wayfair parties over here. And it to me makes it sound like the Wayfair parties did that. And again, if that's the case, if you think that that happened, investigate it. Do a series of articles. Let's see it. And I don't see those articles.
Okay, so I'm going to ask you the unfair question that I always do. You're Judge Lyman. You've now seen the New York Times moving papers. You've seen the opposing papers. I'm assuming the New York Times will file a reply. So that's forthcoming. What do you think is going to happen here?
It's not unlikely. I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint. And the reason why the judge would do that, I mean, think about it. It's not just that he's being mean to Baldoni, but he's also saying, look, why don't you clean this up a little bit? There seems to be a few areas where we could tighten up the complaint and maybe not have to deal with these arguments. So why don't you do that? And it also might keep one of the parties from doing an appeal later on once you get to the end of the case. So you might as well just amend the complaint and clean it up now. So it wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
So overall, I agree with you. I think there's a chance that the judge sides with the New York Times, but I want everyone to understand what that means is more than likely, a very high percentage chance, they're going to say to Baldoni's team, just clean your complaint up, file a second amended complaint, and then let's see where we go from there. But I will say that I think the court could, based upon these arguments that I'm seeing, I think the court could say, hey, I think there's enough done here. I think the New York Times, they're bright. They've got good lawyers. They know the claims that have been made against them. I think they should answer the complaint, Baldoni's First Amendment complaint, and let's get started with discovery and let's see where the case goes. And I think the court could do that if it wanted to at this point in time.
It certainly could. I mean, the arguments were really strong. So that wouldn't surprise me either.
All right. Whew, that was a marathon. So we had a little over 2,000 people. I don't know if we wanted to try to see, Keith, if there was a couple questions here. And I'm not very good at this, but let me just see here quickly if we can find. Can discovery begin? This is MP. Can discovery begin?
Well, the judge stayed discovery as to the New York Times. And so that was their motion that they brought. So discovery can't begin as to the New York Times yet. And I think the judge was thinking that he was going to get through this motion pretty quickly. And he even told the Baldoni parties, why don't you file your response sooner rather than later, and then we can get this resolved and move on to the next step. Discovery can begin with the other parties, though, people other than the New York Times.
Kelly says here that she does not watch mainstream. I'm assuming mainstream media, so that's interesting. And then another shout out to the young associate at Brian Friedman's firm, Jason Sunshine. You're getting some press today. P. Mahone says you have a great name. So let's see.
Yeah, that's a good name. You can click on them if you want.
Yeah. Deanne Dudinsky says, I think that lively parties should also be forced to do community service at a domestic violence shelter and donate to help victims.
Yeah, that'd be nice if that was one of the remedies. I'd like to see that.
This is interesting. We have G. Twohey prejudged the case because she owned Sloan a favor for trove of information on Weinstein case.
Oh.
And I think that was where she did get some of the information.
That's very interesting. So maybe there was, and maybe even if, whether she owed her or not, maybe there was a basis of trust there, so that she just assumed that it was true.
And then
that'd be interesting.
Dia Yusuf on Anabata. I'm so sorry about just completely torturing that name. Curious about the subpoenaed documents that they got. Let's say Stephanie Jones subpoenaed Abel's phone. Can she then share that with Lively? Isn't that privileged information? Good question.
It's not privileged information, although it could be confidential in some way. I'd have to look at the contract between Jones Work and Wayfair, because Wayfair was a client of Jones Work. And so there could be some right to privacy. But as we pointed out, I think when we were going over this on Thursday or yesterday with Zach, the Wayfair parties should have at least been given notice of a subpoena so that they could object if they wanted to. And it doesn't seem like that happened.
So just a statement from Melandro de la Cruz. We need more balanced reporting and analysis.
Yeah.
And I think that's what we need. I mean, that's what people wanted from the New York Times. They want it from the mainstream media. They want it from us. They want you to call it straight.
Yeah. Yeah, just tell us what's going on. And you get so many, crazy headlines, and then you find out that it's not exactly accurate.
Let's see if there's a couple more here. I'm going to go to the very bottom and see if anybody had any more questions.
I've got one here.
All right, go ahead.
So Diane Dudinsky, the subpoena was the same day she fired Abel, ? I'm not sure if it was or not. That's what's so confusing. I know that Jones Work got the phone from Abel when she was fired, but I really don't know.
Yeah, and just so everyone knows, subpoenas take time. I mean, even if the CRD complaint was filed on December 20th, and let's say you can get pre-lawsuit discovery from the CRD, which you and I have determined you cannot. The agency itself could, but not parties. It would take more than a day to get that. And then every other case that we've seen in this case where you potentially could subpoena somebody was filed in like 2025, right? Later in 2025. So there's no way that all of these thousands of pages came from a subpoena. I'm still open to the idea that there was a subpoena and all these thousands of pages came from it, but I just haven't found anybody to tell me what case that subpoena belongs to.
I know we mapped out all the cases that were filed. I mean, the very earliest that you have a filing is December 20th with the CRD complaint. The article comes out the next day on the 21st. Jones and v. Abel, that suit's filed on the 24th. Lively's complaints filed on the 31st. And even the lawsuit in Texas against Jed Wallace wasn't filed until, February 2nd when Jed sued, but there was something filed in January. All of it took place after the New York Times article. I have not found a case yet that was filed pre-December 20th, which is what you would need.
Keith, I am so ashamed because the justice.
Oh, yeah.
Okay. And he's got a beautiful name, one of the most beautiful names. His name is
Potter
Stewart. Potter Stewart, even spelled correctly.
Yeah,
he's
that's
the one.
what it was.
He's the one that said, "I don't know pornography, but I know it when I see it. I don't know how to define it, but I know it when I see it."
It's such a funny thing too, because that just sounds like a judge who wants to look at the pornography. But that is, I mean, it's hard to articulate it.
Okay, here's another question for you, Keith. This comes from KLBG123. If it follows California law, where do they try the case and get the jury? Good question.
Yeah, good question. The answer is New York federal court. So the New York federal court will use California law for the defamation claims against the New York Times if that's what it decides to do. But that lawsuit is being handled in New York federal court, and that's where it would be tried, and that's the jury you would use.
All right. Wow. PB, thank you. $4.99. And again, these contributions, Keith and I are still trying to figure this out, but we will show that these contributions do go to charity.
Yeah. Yeah. So anybody wants to participate or support us, we really thank you for that. But we don't want to take the money. And so everything that's coming in through the badges, we're going to track that, and we'll show you at the end of each quarter.
Keith, has anyone told you guys that we are mommy sleuths now, according to Glamour?
Oh, I don't know what that is, but it sounds good. I mean, moms are hardworking people, so.
Then Gigi says, thank you so much for giving us part of your weekend. You're welcome, Gigi. We're actually really enjoying this. So it's really our pleasure. And here's a good question, Keith. Wasn't it strategic to file the CRD complaint and then file the New York lawsuit? You've been all over this.
I believe it was, and I don't know if that was necessarily their plan, but I got to tell you, after looking at this case, if I were to come up with a strategy of how to do this, I would file the CRD complaint in California, because California has a very liberal litigation privilege statute that applies to SH claims. Even if they aren't filed with the court or government agency, you still have protection. And New York has a very liberal fair reporting law. Now we know that now. And so it's actually a brilliant way to do it.
And shout out here to, Bridget Valentine says, Popcorn's Planet. I just started watching him. He's very interesting. I enjoy watching his.
Yeah, this is a good point.
Posted a video today showing that Twohey had the time to edit a video, read thousands of documents, all of this in one day from the time the CRD to publication of the New York Times article.
You know, she's a voracious reader, I guess. But that is a really good point. How did that happen?
From Anna S. What happens if all the jury have taken Justin's side already before? Well, this goes to jury selection and voir dire.
Yeah.
Can I walk through that?
Please.
So jury selection and voir dire is fun. I enjoy it. I think voir dire is where you win your cases. So what happens is, before we do opening statements in front of a jury and a jury is impaneled, we're allowed to interview the jurors, and the court also wants to interview the jurors. Now, this is federal court, so it'll be interesting to see. I've never appeared in front of Judge Lyman. Some federal judges do not allow the lawyers to do voir dire, and voir dire is where we get to ask the jury questions. Literally, Mr. Smith, how do you feel about this? How do you feel about that? Has anybody here been the subject of a domestic violence issue in their lifetime? Has anybody here known somebody that's been subject to DV and those types of things? So voir dire is a fantastic time for us to get to know the jury. And so what's going to happen is it's going to be Blake's team is going to say, hey, this jury pool is corrupted. Everybody's on Baldoni's side. Baldoni's publicized this case to Kingdom Come. And so we can't get a fair jury. So what they're going to ask is, Ms. Smith, have you heard about this case? And do you have sympathies for either side? Do you feel bad for Justin Baldoni over here? I mean, look at him, poor guy. Do you feel a little bit bad for him? And if Ms. Smith says, yeah, I feel bad for him, and I think that Blake Lively is a horrible person, and that person's going to be off for cause, right?
Yeah.
So that's a cause challenge, we call that. We also have peremptory challenges, and I think the peremptories are more interesting here, because peremptories, you're limited, and I don't know what it is in Judge Lyman's courthouse. It's usually 6 or 8 peremptory challenges. You can kick people off the jury for any reason, but you can't do it because of their race. You can't do it for any of the protected class reasons, like if they're women or men. But what's interesting here is, who is really supporting Justin Baldoni here? Is it older women? Is it younger women? There will be some research done by jury consultants. And when when the jury panel is close to being seated, and you have that one juror you just don't like, I forget the movie with Gene Hackman, Runaway Jury.
Runaway Jury, yeah.
This is a really, that's basically what the whole movie is about, is picking the jury. And they do a lot of research on these people. And if you have that one juror that you just can't pin down, that they're a Democrat or a Republican based off research you've done on them, where they work, you've done a lot of time, but you just don't feel comfortable with them, that's when you use your peremptory challenges.
Yeah, it's a really interesting process. And I think they will be able to find a jury who hasn't heard of this case, believe it or not. But we'll see. I've got one here. Let's see if we can get this one. So this is Starry Eye. If it's actually a subpoena, how will this impact New York Times? Or is it minor and they can still be dismissed? I mean, at this point, I think they can still be dismissed, even if some way, somehow, they were able to show that there was a fake subpoena. But there could be other consequences for the parties who orchestrated all of that, depending on what they find out. So that's why discovery is going to be so important in this case, to find out what really happened here.
Every once in a while you see somebody post that you just want to know more about this person, and you just want to know, who is this? who is this person involved in this chat? And here we've got an
producer Eric
Ainson.
Yeah,
is that what it is?
I know.
So that's producer Eric, and he's chiming in. It's good to see you, producer Eric. It's a Saturday, so we don't expect you to be in here helping us today.
Well, I'll tell you what, we're trying to do your job, but we're doing a poor job of it. And believe me, you haven't lost your place here.
Keith, won't it be difficult to get an unbiased jury in New York now?
It could be. I mean, there's, millions of people in New York, and I think that there are a certain segment of the population who have not heard about this case. That's hard for me to believe because we're kind of living and breathing this case. But they should be able to find a jury of people who have not heard about it.
Another good question, and this is from Stacy's Stories Science Fiction. If they use California law in New York, how does the judge keep up with the law during the trial? I am assuming he's more familiar with New York law, or is that not how federal judges work?
They do have to keep up with California law, but usually it's kind of the attorney's job to educate the jury about what the law is that they're applying. And then they would use jury instructions, and they would look at the jury instructions from California and probably apply those as well. So procedurally, the case isn't being conducted under California law. It's just the substantive elements that the jury is going to decide are going to be based on California law. And any federal judge could apply California law no matter where they are, because they can read the elements. And so there's, 3 elements, there's 4 elements that the jury has to decide. So it's not that difficult for the judge to do. And it happens all the time in federal court.
Anna S., what happens if the jury have already heard all about the case and even perhaps agree with Justin before going in?
If everybody in New York has heard about this case and agrees with Justin, that's when you get these motions to move the venue to a location. That happens sometimes with like high profile murder cases where they get, you have to move the venue to somewhere. I don't know where you would move it to where people haven't heard about this case. I think there's enough people in New York who haven't heard about this case. There's millions and millions of people in New York, and not all of them are paying attention to this.
All right, Keith, there's a few more questions here, but I think we've come to the end. Again, we love the comments and questions. Keep them coming. We were glad we could spend a little bit of our Saturday with you and go over this interesting case.
Yeah.
Now we're just waiting to see if the New York Times files a reply brief.
It'll be interesting. Yeah, we'll definitely keep you informed about that. But thanks for tuning in, and we'll see you next week.
All right, we'll see you next week. Have a good weekend.